Thanks, everyone. We might get started. My name, for those who don't know me, I'm Associate Professor Tess Hardy. I'm the Director of the Centre for Employment and Labour Relations Law. This event is also supported by CADE. Unfortunately, Professor Jeannie Patterson couldn't join us tonight, but I am very appreciative of the joint support of CADE in this event. But I'm particularly delighted that Jeremias Adams-Prassal is joining us not only for this event, but as a visiting scholar. So we've had Jeremias over for a couple of weeks and we've got him for a few weeks more. For those who don't know Jeremias, he is a professor at Magdalen College at the University of Oxford. He's read law at Oxford, Paris and Harvard, and he has many articles and books, including Humans as a Service, The Promise and Perils of Work in the Gig Economy. He's currently working on another book, I understand, and as part of a major 5-year project that he is currently leading on regulating algorithms at work. So it is my pleasure that Jeremias is coming along to present this seminar. He'll be talking for approximately 40 minutes and we'll have some time for questions at the end. For those who are attending online, please feel free to add your questions to the Q&A tab, and I'll try to ensure that those questions are asked in good time. And before we officially get started, I also want to acknowledge that we are on the lands of the Wurundjeri people of the Kulin Nation, and I wish to pay my respects to elders past and present, and to acknowledge any Indigenous Australians that are joining us here tonight. So over to you, Jeremias. Thank you.
Thank you, Tess, for this kind introduction. And I too would like to very much acknowledge the Wurundjeri people who are the traditional custodians of this land, and pay my respects to the elders, both past and present. Thank you so much, Tess, for hosting us here today. And thank you both to the Centre for Employment and Labour Relations Law, as well as the Centre for AI and Digital Ethics, for bringing us together. This is originally part of an exchange thing that Tess and I did quite a few years ago. So I think the Alan Myers exchange program also ought briefly to be thanked for actually finally being able to have the return leg of when Tess came to visit the Oxford Law faculty 1 or 2 years before the pandemic. The other important thing I should note in the beginning is that what I'm going to present to you about today is very much not just my own work, but it's actually the result of work that I conduct with the interdisciplinary team based at Oxford and funded by the European Research Council. And the team includes all the nice people you see on this slide: Halifam Abraha, Ashley and Kelly Lyth, Sang Rakshita and Sig Silverman. And really what we're presenting in this slide deck is very much the work of our joint efforts. So normally when we tell people that we work on AI and the future of work, the sort of standard response you get is, oh, is this all about robots coming for workers' jobs? And our answer to that is they may or may not be coming, but that's not really what we're interested in. What we're interested in is what happens when emerging technologies come for management jobs. In other words, when all the traditional functions of employers, from hiring workers to managing the day-to-day operation of the enterprise, all the way through potentially to firing workers, start to become either augmented with technology or actually fully automated. Now, one thing that's interesting about algorithmic management is that it started very much in the gig economy. So I first came across algorithmic management when I was thinking about these myths of entrepreneurship and sort of freedom you get surrounding the gig economy, when the reality is, instead of entrepreneurial freedom, actually very tight control through rating systems and various other automated ways of manipulating the working environment and exercising the managerial prerogative. And one thing that's interesting is that while this started in the gig economy and started in sort of discrete areas, pretty much at the bottom of the labor market, warehouse management, another big case study, what we've seen in recent years is a spread of algorithmic management right across the socioeconomic spectrum. It really no longer matters whether you work as an Uber driver or whether you work in an Amazon warehouse or whether you work in a professional services firm, even a university. The kind of technologies we're looking at in terms of the surveillance and increasingly also the actual exercise of control is coming to workplaces right across the spectrum. Had a bit snoop through your local version of Teams here earlier in preparation for this talk, discovered that Tess is my line manager whilst I'm here. So, Tess will have full visibility and control of everything I do on MS Teams. Fortunately, I've got another version as well that might not be visible, but it's just, it no longer matters what kind of element of work we're looking at. The other thing, of course, is also the fact that the COVID-19 pandemic led to an explosive growth of these technologies. If in February 2020, we would have told workers that they had to install cameras in their bedrooms and kitchens, you would have had the biggest unionization drive in history on your hands. Yet a year later, that actually had become a completely normal baseline. And actually, one thing I think that's really, really important as we move out of the pandemic and think about sort of policy approaches to algorithmic management, that cannot be the baseline. The baseline has to be what was in place before the pandemic, rather this sort of widespread normalization of surveillance through remote working. Now, when you look into the literature surrounding algorithmic management, there are some positive use cases, but much more disconcertingly, there's also lots of stories about what happens when things go wrong. And there are lots of sort of, increasingly both in journalistic reports, but also in some of the academic, anthropological and sociological literature, sort of horror stories you can find very quickly in terms of the deployment of algorithmic management systems. Systems that are deployed in hospital, for example, to rate the productivity of different hospital workers. And for the chaplains, actually conducting a funeral is seen as a more productive use of their time than actually ministering to the sick. Now, this is just one of many illustrations where you try to quantify certain elements and they simply go wrong. More fundamentally, I think there's two big categories of errors and problems that we see in the system. One is where the system actually works as designed, but simply has inherent flaws and problems. And the sort of stories we have about algorithmic bias, but algorithmic discrimination are a classic instantiation of this. So again, one of the stories that might even be a bit too convenient, but Amazon apparently recognized itself that the recruitment system it had for engineering positions was systematically discriminating on grounds of gender. So that's the first kind of error we need to think about, where it works as advertised, but actually there's inherent flaws. The second category that in a sense is more fun to think about, or at least to discuss, is when the system is simply snake oil, when the system advertises a capacity that it can't have. This is the sort of thing where you advertise a 5-minute video interview that then at the end supposedly gives you scores on how good somebody is in terms of their teamwork capability, or how good they are in terms of engaging clients on various forms of communications. You might as well use a random number generator. Nonetheless, there's quite a lot of power in the sort of saying, oh, we've got the shiny AI software here for you. Yet then actually it doesn't work as advertised at all. So that's the background against we then really want to ask 3 fundamental questions, I think, that are at the core for us as lawyers to think about. First, are we actually looking at a genuinely novel phenomenon here? Is this truly new? Because one thing we have to be very careful about is just because technology that is being deployed is new and shiny, doesn't necessarily mean that we're looking at a new regulatory challenge. And the gig economy in and of itself is a classic illustration of that. It doesn't matter whether you dispatch people through a paper system or through a fancy app. It's essentially just misclassification come all over again. But nonetheless, that's a question, is this novel? And in particular also, which elements of it, if at all, are novel? Even if we find some answers to this question and say, yes, there are features that we need to think about as novel, that still doesn't necessarily mean that existing laws no longer apply. Again, I think that's a narrative we have to be very careful about, of sort of saying, oh, shiny new technology, therefore out with all the old, let's have lots of new rules. Well, it takes a lot of time to make them and therefore then creates a lot of space for economic activity to exist beyond the realm of legal regulation. Nonetheless, we then also want to think about where and also why certain new rules are required. But I really want to be at pains to make it clear that the fact that we are in this blueprint talking about suggestions for new rules should not in any way, shape or form be taken as saying that the existing rules of the game don't apply. And actually, that's a sort of issue with AI regulation more broadly. We have to be very, very careful that as we develop new rules and think about emerging rules, that cannot be mistaken as a way of getting out of existing regulatory rules and obligations. So let's start first with a question as to whether this is genuinely a novel phenomenon. And we have 3 sort of hypotheses or 3 fault lines along which actually we might be looking at a genuinely novel challenge here in terms of the collation of information, in terms of the processing of that information, and in terms of how we have to think about when things go wrong. Now, in terms of data, first of all, you could say, well, employers have been collecting data about their workforce for about as long as employment has existed, right? CVs, performance reviews, etc. But what we're looking at here in terms of collection of data is fundamentally different from a paper record stuck somewhere in the back of a filing cabinet in the HR department. We're talking about the ubiquity, the constancy, and the comprehensiveness of data. We're talking about badges worn by employees to swipe in and out that can measure everything from the frequency of your voice to your heartbeat and who you actually hang out with. We're talking about metadata analysis of communications that then can be combined with room booking information, etc., etc., etc. So both in terms of the granularity and the intimacy of the information we can now suddenly start collecting, I think we're looking at a fundamentally distinct regime. There's one employer, at least I'm aware of, who actually offers their workforce Fitbits, and in return for the data, if they sleep at least 8 hours a night consistently, they get paid a bonus, which sounds nice to be paid extra to sleep well. But then you think about the implication of what else you can read out of that information and what you can learn about your workforce, it becomes quite creepy quite quickly. Okay, so we collect a lot of data, and we collect them very differently from what we've done before, and vastly more of it. That's the first big difference. The second one then comes to what we actually do with that information. And that's where AI or various machine learning techniques come in. The reality, of course, being that a lot of these applications use a combination of more traditional forms of software and various elements of machine learning or AI systems. But really what we're suddenly looking at here is being able to draw inferences on a vast range of features, often also on a dubious range of features. Again, this goes back to this point about how do we measure productivity, for example, in lots of different workforces. Also, crucially, and we'll get back to this point when we think about harms, I can process information now in a way that implicates not just present data subjects. So I'm not just using information about you to make a decision about you. I can also start trying to use that information to make decisions about future data subjects, try to start profiling people, try to work out who might be a trade unionist, or try to work out who might want to exercise legal rights against an employer. Finally, and in a sense that might be the most controversial one, or certainly inside the team where we have lots of discussion about, we also have this working hypothesis that when things go wrong with human managers, which of course they do, and employment lawyers wouldn't have a job if all managers were these perfectly lovely, nice people. But nonetheless, when a human makes a mistake, that is fundamentally different in the kind and types of mistake we see than when machines make them. And a sort of simplified way of thinking about it is that essentially to a large degree, human mistakes are stochastic, they're random. If you apply to 10 different jobs with the same CV and you've got 10 different recruiters, you might get through somewhere, you might get through otherwhere. This is of course not to say that we don't have lots of systemic biases, conscious and unconscious, but nonetheless in the actual application scenario, there's a degree of stochasticity. That's very different from machine errors, where essentially what you have is very deterministic error. You feed the same CV into the same system, you are going to get the same sort of outcome. And so when you end up in one of these machine constructed outlier groups, you will essentially always be penalized by the system. You might not even know why it is that you end up in this machine constructed outlier group. Might be a correlation with protected characteristics, might be something completely random, that completely random points in the decision surface sometimes. But once you're stuck in there, and everyone uses essentially the same model that's been trained on similar kind of data, then you are stuck and you can apply however many times you want. You will always be rejected from that particular job. So those are the three kind of things that make us think, actually, there is a reason to think harder about, do we need new rules or can we just rely on existing regimes? And just to make very sure that I am not misunderstood, let's have one quick slide on some examples of where we can actually use existing rules, some of the work we've done. So we've argued, for example, that discrimination law, both in the EU and the UK context, can be used much more aggressively against forms of algorithmic discrimination than has been traditionally assumed. The standard assumption tends to be that algorithmic discrimination can only be combated with indirect discrimination, that the automated system is essentially this neutral provision criterion or practice, which therefore opens up a space for automation. Together with Ruben Binns, a colleague in the computer science department in Oxford, and Ashlyn Kelly-Lyth, one of our team members, we've argued in a recent piece in the MLR that actually there are particular instances of automated bias that actually clearly fall within the scope of direct discrimination, which then, of course, in terms of its knock-on effects, has huge consequences, because it means that essentially you could never justify the deployment of such a system. And certain kinds of facial recognition fall into that. The other really interesting area, and also the, I guess, most challenging one for us employment lawyers sometimes, is the recognition that data protection is becoming increasingly important and plays an increasingly important role. And so what we see, for example, is litigation against some gig economy companies in Europe at the moment, brought no longer as an employment claim, but actually brought as a data protection claim. So you could take your standard unfair dismissal claim against Uber, and then, of course, the first thing you do for 5 years is litigate all the way up to the Supreme Court and back whether the individual is actually an independent contractor or has the right. Well, you can shortcut that if instead you say, under the GDPR, Uber used a fully automated system to decide which workers to terminate, and therefore violated the data subject's right under Article 22 GDPR. And that cuts right through that status question. Now, there's some disadvantage potentially as well in terms of framing workers' rights as data rights. And it's something we can maybe talk about more in the Q&A. But I think it's just important for us to sort of, and certainly employment lawyers, like many other lawyers, I suspect, have this sort of deep fear or suspicion of the GDPR and then sort of the complexity of data protection regimes more generally. But really, we can't afford to ignore them anymore. And I think we'll see a lot more claims framed as data protection in various ways. Okay, having said that, though, let's get into the more interesting things. What are the actual regulatory gaps? Even once we've pushed, say, discrimination law, or say, data protection law out there, we think we can identify two broad categories of issues where there are clear gaps in our existing law. The first of these gaps is a massive exacerbation of privacy harms and information asymmetries. And again, with this one, you could say, Jeremias, some extent, information asymmetries have always characterized the workplace. To some extent, privacy issues have always been present in the workplace. But nonetheless, I think, not least for the reasons I gave on the earlier slide about sort of the fundamental differences that we now face, actually, we're talking about a difference in kind here rather than a difference in degree. And so actually, we do merit having specific responses. What do we mean by those harms? Well, in terms of privacy harms, I suppose sort of the classic range of individual privacy harms, thinking about reputational harms, to saying, look, Jeremias is actually a slacker, but also autonomy harms, the way you can actually deploy this information to manipulate the workplace. Puts up a big thing saying, Jeremias has packed so many packages today, Tess has packed that many packages today, and actually try and gamify the workplace, and actually use that data to exercise more and more pressure and control. There's also then that sort of second really interesting category, thinking about sort of collective, or as Viljoen calls it, relational harms through the data. And that's really this kind of thing where I take a data set about existing workers and then try and use that information to make predictions about future workers. To say, actually, X might be quite likely to be a trade unionist, and therefore we're not going to hire them. And again, these are not hypothetical scenarios. That kind of software is widely deployed in the United States, for example, as is even software, so I guess the most horrific end of the spectrum, trying to work out when somebody might get pregnant or have a particular disease, to be able to terminate them before various legal protections start to apply. So those are the kind of harms we can see here that are essentially privacy harms, but at a degree hitherto pretty hard to imagine. When it comes to the information asymmetries, again, what's going on is a lot of sort of knowledge extraction, a lot of tacit knowledge in particular. As we monitor more and more tasks that are happening, having systems learn about how workers perform those tasks eventually makes those workers much easier to replace and weakens their bargaining power. This is also information asymmetries that can arise as the result of inferences. And that's important, again, to think about. With artificial intelligence, the key word is not intelligence, the key word is artificial. So something might potentially have a high predictive power, but a prediction would also be completely wrong. I could match in all sorts of ways at a 90% likelihood the characteristics of a traditional trade unionist, but might have in my past life had a horrible trade union experience in a previous job, and so would never again join one. Yet nonetheless, I might end up being targeted by an automated system on the basis of various inferences. And the issues with information asymmetries, again, in principle, sort of the traditional economic approach is to say, well, having more information overall will lead to better productivity. But the reality is that that's not the only way in which you can use that information. And so work by Benkler and Bargill, for example, has shown quite clearly the sort of temptation and practice for employers to exploit these information asymmetries, not to increase productivity overall, but actually to exercise more power, to exercise more control over individual workers. And again, the gig economy is the most extensively studied context of deployment of that, but we're also starting to see it in various contexts across the socioeconomic spectrum. So that's the first category of problems then any new legislation or proposals have to deal with. Privacy harms, information asymmetries. The second category of harms we want to think about is what, broadly speaking, we call the demise of managerial agency. And that's really this transformation of the way that traditionally power was exercised, the managerial prerogative was exercised in the workplace, where under the sort of Coasian model of the firm, you have the contract of employment, the contract of service. It's this key trade-off point between, on the one hand, protection, but on the other hand, submission to the managerial prerogative, taking out the kind of free market transactions that we normally have and replacing them with managerial control. Now, what we are seeing increasingly is both the augmentation or even the full automation of the exercise of the full range of employer function. Augmentation might be where human still makes the final decision, but gets very clear ranking scores for candidates, for example. Automation is a scenario where the full decision is actually taken. And again, I'm not talking about hypotheticals here. There's a lot of concrete evidence of software deployed to both ends. Now, the reason why that is a problem is both sort of from a broader workplace point, loss of agency, and then there's a very particular legal worry I've also got. So from the broader workplace relations point, I think the loss of agency of the human manager is hugely important, both in terms of practical agency. So this is the sort of, things that are critical to empathy, to flexibility. You see that the weather outside is horrible and somebody is a bit late for work. Well, you might have some empathy rather than saying, sorry, this was your third strike, you're gone. But there's also a broader sense of moral agency, I think, that's really important in terms of the dignity of work, in terms of the alienation that you have when you get fired by email or you get fired by an automated system and there isn't even a human being to explain to you what happens. I simply say, Jeremias, you're terminated because you didn't comply with our terms and conditions. So there's a huge sort of, I think, alienation, dignity concern we also need to think about. But as lawyers, of course, we can zoom in on something even more important. And I think that's a sort of loss of legal accountability that starts to be inherent in the deployment of some of these technologies. So in my work, I've always been really interested in how people use complexity and exploit complexity to avoid responsibility. But historically, the things I've studied were using legal complexity to escape liability. Corporate structures, contract misclassification, etc. And there, at least in principle, and I say in principle, it's been practiced, the devil can be in the detail. But at least in principle, if you use a legal trick to evade responsibility, I can pull a legal answer somewhere out of the toolbox, right? You use lots of different corporate shell groups. Well, in theory, I can pierce the veil. You go down sham contracting route. Well, at least in theory, though not in this jurisdiction anymore, I understand, but in just about every other jurisdiction, you can use primacy of fact to get around any sort of sham contractual arrangements. Now, what I'm really worried about here is that if increasingly we see this disintermediation of control, which is really quite distinct from the traditional bureaucratic structures of the workplace, we see this disintermediation, the complexity, the evasion of responsibility might start to be inherent in the deployment of the technology itself. And it's no longer clear precisely how we attribute liability. And of course, these legal attribution mechanisms traditionally have always been structured around the human decision maker. Employment law, legal regulation more broadly, doesn't stop the exercise of the managerial prerogative. Indeed, you look at the work of people like Simon Deacon, they say it's the exact opposite. It is law that first actually, as it were, legitimizes the exercise of that control, of that power. But it does put certain boundaries on it, both through ex post facto and ex ante various sanction and rule structures. And the moment we move away from that individual human being being in charge, I think we start seeing a lot of problems for legal accountability. One of the sort of most concrete illustrations I've come across in the case law on this is a case in Baltimore brought against Amazon for essentially trade union victimization. So this idea that, in a dismissal scenario, you specifically pick trade unionists to get rid of them. Amazon's response was to say that the local management who ran the plant, the warehouse, neither understood nor had any control over the system that fired the workers. It was essentially provided fully automated productivity measurement system that picked the workers and sacked them. The only thing the management could do is in the run up to Christmas and Prime Day, stop the system from sacking anybody because they needed as many hands as possible on deck. But beyond that, imagine you're the boss of a warehouse with a couple hundred employees and you don't understand or control the system that decides who to fire, right? That's the sort of illustration. And of course, on the facts of that case, it was a good defense to run because it meant that you could show that like management hadn't targeted trade unionists. But if you take a step back and think about it more fundamentally, how are we going to ascribe responsibility when lots of people will just turn around, or the traditional targets, as it were, of our description of responsibility can just turn around and say, sorry, computer did it. So that then are the two challenges that any kind of new regulation needs to think about and needs to tackle. And what we've done with the team, we've really tried to sort of think specifically about these shortcomings that I've just talked about. And then we've gone through lots of different, legal systems, lots of different reports, proposals, studies to come up with targeted ideas as to how we can address those two categories of challenges. Let's start with the privacy harms and overcoming these information asymmetries. Well, for a fairly short, but nonetheless really important series of abuses of algorithmic management, we actually think that we need clear red lines. We need clear prohibitions and just say there are certain goals to which you can never deploy the kind of system. There might be key contexts, so monitoring people outside work, monitoring private spaces, bathrooms, etc. But also, I think increasingly, the way the technology changes, the kind of context or the kind of data you look at is no longer as important as the purposes to which you then deploy them. So in the GDPR, again, for example, we have a category of special category data. So things like your health data, various protected characteristics, trade union membership, where heightened obligations apply. Now, because of inferences, I no longer need to know your sexual orientation. I no longer need to know whether you trade unionist or not. Indeed, not having that information in the data set makes it much harder to prove that I have ended up discriminating. So therefore, thinking instead of categories of data or contexts, I think a shift needs to happen about the purposes to which you deploy these automated systems. And there we think, for example, about any form of emotional or psychological manipulation. So a lot of the gamification of the workplace would fall into that category. But also actually the prediction or the exercise of legal rights is really important. So any kind of scenario where I try to work out who's going to get pregnant, who might want to join a trade union, there's just no context in which you should ever be able to justify or explain why this is a proportionate interference with fundamental rights. Beyond prohibitions and red lines, we also think that the legal grounds for processing should be limited. So one of the big sort of battlefields that you see at the moment emerging in various European member states is this idea that an employer can say that she's got a legitimate interest in processing information. So again, this is live litigation running against Amazon in Germany at the moment, where the data protection authorities said this collection of vast amounts of information with handheld devices and control of workers went beyond Amazon's legitimate interest. Amazon appealed that, and in an administrative district court actually won. I'm 99% sure that that case will go all the way up to the Luxembourg Court of Justice of the European Union. So it's really one to watch. But one way you could just think about limiting that at the outset is to say some of these traditional grounds of processing. Consent, of course, is another key one, because consent, given the inequalities of bargaining power in the workplace, can never truly be freely given in that scenario. So by limiting the grounds for processing to essentially anything that's intrinsically connected to and necessary for the performance of the contract, you might be able to cut off some of those sort of most egregious deployments, whilst on the other hand, still giving some space for employers to deploy legitimate systems. Proportionality, again, I think should increasingly be seen to play an important role. Because remember that sort of second category of problem I talked about, the sort of snake oil AI, or technically the kind of validity of these systems, actually would be really important to mandate that employers or developers of software show that a software is actually capable of achieving the goals it promises to do, and that it does so in a proportionate means. So actually proportionality, fairly underused tool sometimes in data protection contexts, could be really important to help us with this technical validity as well, to say, what can you deploy and where do you have to be more careful? Now, with information asymmetries, finally, one way of dealing with them is to try and balance it out, right? If the employer's got lots of information, the worker has got less, you could try and have various notice provisions providing information. You can do that both at the individual level, just saying, actually, here are the systems I'm deploying, here are the key elements of the system and how they operate, but also crucially provide those collectively to workers' representatives. One reason for that, of course, is that if I give you too much information, actually information overload could also be a thing, right? If on your first day at work, you get this extremely detailed spec sheet of every algorithmic management system that's being deployed, well, that's also pointless. So maybe having some other collective mechanisms. And again, that's something that's being litigated at the moment. For example, whether workers have to have individual access or whether union can request access on their behalf. There's also then really interesting questions about sort of format and accessibility. Can you have API access? Or can you still, so one thing Uber tried to do is just give workers their data physically printed out, which of course is very different from having direct API access to a particular database or system. But so those are the first four proposals we now have to really think about how we deal with the information asymmetries. Essentially have that asymmetry and say, we're going to deal with it by banning some things entirely, some things you're not allowed to collect, you're not allowed to do, but also try and level it out by sharing information and sort of, raising awareness of the availability of these systems. The second broad context, or sort of second broad area where we need new rules we've identified, is this demise of managerial agency. And so there then we really want to think about how can we restore human agency. Now, the sort of traditional historic response to this question is to say we want to have the human in the loop. Or as we lawyers think about it, we want to have bans on fully automated decision-making. And Article 22 of the GDPR, Article 22.1 in particular, is a classic illustration of this kind of ban on fully automated decision-making. However, lots of literature, both legal literature, but also the broader kind of socio-technical systems literature, has shown that the human in the loop is not the solution to this loss of human agency. That actually often the human in the loop just becomes a rubber stamp for the automated system. Indeed, that performance of both the human and the automated system will degrade over either of them performing individually in this kind of context. So that's why actually we don't go in quite strongly on humans in the loop. After much back and forth and discussion, we decided to suggest a termination of the relationship. That should be the one where actually you might want to have a human in the loop requirement. So that the very existence of the contractual relationship is so fundamental that actually before that's being terminated, you should have some sort of human in the loop provision. But beyond that, we don't actually think that human in the loop is the solution to the agency problems we've identified. Instead, and this is where our loop technology might get a bit loopy, we think that we want to have humans before the loop, humans after the loop, and humans above the loop. Okay, what do we mean by that? So humans after the loop essentially tries to create a very concrete right to a human review, right? Essentially think about creating a clear avenue for human contestation of an automated decision. Because when you think about, there are lots of decisions that can be fully automated that nobody would want to object to. If you get the loan, if you get the job, well, you're not going to insist on a human actually reviewing that decision and maybe changing the outcome. But overall, in order to ensure accuracy and the validity of decision-making, that contestation is hugely important. We think here about individual requests in terms of, written explanations, a discussion, a review. There is a literature out there that says, does such a right already exist in the GDPR? Does it not? Well, actually, you'd make life much easier for both employers and employees if you just concretize that right and just say it definitely exists in the workplace. And again, different industrial relations systems will already have such methods of contestations, will already have such various ways of challenging it. Also really important link to that is not just a request to review, but also rights to rectification. If it turns out that in light of that review, the decision was not valid and a different decision should have been arrived at. In addition to having humans after the loop, contesting individual decisions once things have gone wrong, we also want to think about humans before the loop. You'd want to think about the data subjects, the workers, actually being involved both initially and on an ongoing basis in decisions about the design and the deployment of these systems. Now, how that works in practice will be very industrial relations specific. So I guess German industrial relations model might be the gold standard here. Works councils, worker elected representatives, actually have a veto right over the introduction of new technologies in the workplace. And so what you end up seeing is actually employers going to the worker council saying, here's what we'd like to do, and then sitting down for serious discussions as to which features might be deployed and which features might be just too creepy and not deployed in its place. So there's real evidence that actually that leads to much more sophisticated deployment of the technologies. Because another reality is, of course, that whilst the likes of Amazon of this world will build their own HR systems, hiring systems, the vast majority of employers will buy this kind of stuff off the shelf. And so there needs to be customization anyways. In a sense, you could then get some tech consultants to do that for you, or you could get the workers. And there's, again, sort of in the STS literature, lots of interesting stuff about how introduction of new technologies can fundamentally change existing dynamics in terms of power structures within the workplace and more broadly. And so actually having representation from both sides at that moment, again, in a sense, we think of this as a good point of contestation that ends up improving the overall solution. Now, there's lots of really cool work done by people on sort of participatory design of algorithms, for example, in the gig economy context. And in a sense, that will be the gold standard. But that may well not work because Microsoft probably has a legitimate point in saying not everyone who will ever use Teams should be involved in us designing the latest iteration of the software. That said, one thing that's important to realize is actually, even if you buy the software off the shelf, there is lots of configuration going on. So I don't think it should be an excuse to say, actually, I'm just buying in this software, when you realize that in everything from facial recognition through to what kind of metadata you analyze or how you exercise instructions to workers actually can be configured properly. And some countries like the Netherlands actually have shown really interesting success there in saying, actually, if we're procuring particular software for the public sector, we don't want certain particularly creepy features built in. And that's then enough bargaining power for the software actually specifically to be designed in a certain way. Finally, we also want to have the human in the loop, because while it's important to have individual avenues of contestation, and whilst it's important to also think about how systems are designed in the first place, one of the problems is that when things go wrong with algorithmic systems, that don't necessarily go wrong in the way that we would have traditionally thought about liability regimes. Right? That's a big problem with the AI Act in the EU at the moment, that it tries to use a sort of product liability regime. Super easy to work out when your coffee machine has blown up or a chainsaw has taken your leg off. Much harder to work out that harm is instantiated when it's non-material harm, when it's a fundamental rights violation, when your chance of getting a job because of a particular protected characteristic has dropped by 10 or 12%. Much more difficult to work out how that harm has instantiated. And so what we suggest is some sort of algorithmic management impact assessment, where both ex ante, but then crucially also on an ongoing basis, you report on the system level implications, on the impact on a full range of working conditions. And you see, interestingly, some states in the United States are already doing that in the recruitment context. So in Chicago, for example, employers who use automated recruitment systems need to, on an annual basis, actually report on the various statistics and the implications of deploying that system. That is, of course, also really, really useful, because then when you think about burden shifting and discrimination law, when you think about even just working out which cases should be enforcement priorities, having that data can be incredibly helpful. And certainly if in a legal system where the sort of prima facie evidence of discrimination leads to a burden shift, that then takes the whole sort of black box category of problems and puts them in the hands of the developer or the deployer of the system. Finally, there's also publicity, right? I mean, as academics, we always have to say, oh, wouldn't it be lovely if we had access to this kind of information for research so we can actually play with the data and see what's going on. But I think there's important trade-offs there as well, of course, in terms of confidentiality obligations. Again, using employer representatives is interesting there. And you see really good case studies, because that's a way around some of the confidentiality things, because you share it with the representatives, but they then are subject to the confidentiality requirements. So some of the kind of IP sort of trade secret kind of problems you can actually get around by having targeted representatives to whom you disclose the information, and you can sidestep that problem. That's it in terms of the proposal. I think our overall thing is that, you know, potentially there might be some good use cases for technology. This is a much cited, this is the patent that Amazon actually put in for its wristbands that guide workers through the warehouse. Now, there are productivity enhancing ways in which you could deploy this technology. If I just give you a paper list of stuff to find in a cavernous warehouse in the morning and then say, off you go, you're going to waste a lot of time running up and down, etc. Definitely within the capacity of a clever automated system to build the best possible route through you and then actually show you how to do it. Not a particularly controversial deployment. Using the same scanner then, however, to measure exactly how quick you are, give you a time that counts down in green and starts counting up in red when you've exceeded your allotted time, putting an extra sort of 10% pressure on you on a regular basis, well, that's obviously a deeply problematic deployment of the very same technology. I think that's where legal regulation then has to come in to make sure we don't fall into a kind of sort of tech deterministic dependency where we think, oh, there's only one path, only one future of work. There are lots of different futures of work, and regulation is key to getting it right. Thank you.
Thank you again, Jeremias.